The Domestic Violence Act, Part 3, General. Section 13, Interim Orders. Subsection 1. Every interim order made under this Act on an ex parte application shall specify a date for a hearing which shall be as soon as reasonably practicable thereafter, to determine whether an order shall be made in substitution for the interim order. Subsection 2. The copy of an interim order which is served on the respondent shall notify the respondent, that's the person being accused of domestic violence, that unless the respondent attends court on the date specified therein to show cause why an order should not be made in substitution for the interim order, the court may discharge the interim order and make an order in substitution thereof. Let's just look back at interim order, the definition. We're at page 11. I try to remember to return to page 11. Interim order. Looking for interim order. What is an interim order? I seem to remember, it means an order that expires automatically. But I'm not seeing it back in the definition. But I think the interim order is an order with an expiry date. Other orders would only be cancelled where a protection order, whether interim or otherwise, is made. Alright, I think the interim order, it has a short expiry date. Other orders may have to be cancelled by the court, but let's return to page 11. Alright, we'll continue. At the hearing referred to in subsection 1, the court may A. Discharge the interim order, B. Discharge the interim order and make an order in substitution thereof, or C. On good cause being shown, adjourn the hearing to such date and place as the court may specify. 4. Where a hearing is adjourned under subsection 3C, the court shall, at the adjourned hearing, exercise either the power conferred by paragraph A or B, or that subsection. 5. In this section, interim order means in this section, interim order means an interim protection order or interim occupation order, as the case may be. Order means a protection order or an occupation order, as the case may be, not being an interim order. Section 14, Conduct of Proceedings. Subsection 1. No person shall be present during the hearing of any proceedings under this Act unless such proceedings are criminal proceedings, or the person is A. An officer of the court, B. A party to the proceedings, C. The attorney at law for a party to the proceedings, D. A witness, or E. Any other person permitted by the judge to be present. Now, no person shall be present during the hearing of any proceedings under this act unless proceedings are criminal proceedings. Okay, so members of the public can freely attend criminal proceedings, but for other proceedings, the judge will have to give them permission, or they will have to be any of these persons listed here. Anyway, 2, subsection 2, any witness shall leave the courtroom if asked to do so by the judge. 3, nothing in this section shall limit any other power of the court to hear proceedings in camera or to exclude any person from the court. So the court can hear proceedings in camera, that means secretly, away from other persons. Section 15, standard of proof. Every question of fact arising in any proceedings under this act, other than criminal proceedings, shall be decided on a balance of probabilities. Okay. So these statements apply to this act, the Domestic Violence Act. Probably they don't allow members of the public generally, because some people might just be curious and want to find out what's going on with somebody else and maybe spread rumors, or just being inquisitive and mischievous to find out what so and so did to their wife or husband or boyfriend or girlfriend or children or child or whatever, what the case is. But anyway, section 16, restriction of publication of proceedings. Subsection 1. Subject to subsection 4, no person shall publish any report of any proceedings under this act unless he is first granted leave of the court which heard the proceedings. Okay. 2. Every person who contravenes subsection 1 commits an offense and is liable on summary conviction to a fine not exceeding $25,000. Subsection 3. Nothing in this section limits a. the provisions of any other enactment referring to prohibition or regulation of the publication of reports or particulars relating to judicial proceedings, or b. the power of the court to publish any contempt of court. So the provisions of any other enactment, the power of the court to publish any contempt of court. Alright. Subsection 4. This section shall not apply to the publication of any report in any publication that a. is a bona fide professional or technical nature, of a bona fide professional or technical nature, b. is intended for circulation among members of the legal or medical professionals, officers of the public service, psychologists, marriage counselors, or social welfare workers. Okay. So these persons may freely have access to the publications, but not the general public, whenever there is domestic violence cases in the court, or there are domestic violence cases in the court. 17. Section 17. Orders by consent. In any proceedings under this act, the court may make an order by the consent of all parties to such proceedings. Subsection 18. This court may, on making an order under this act, recommend that either or both parties participate in counseling of such nature as the court may specify. Okay, so the court may send them to family counseling, marriage counseling. Alright. Section 19, appeals. Subsection 1. Any person aggrieved by A. The making of an order by the court, or B. The refusal of the court to make an order, may appeal to the Court of Appeal. Subsection 2. Except where the court which makes an order under this act otherwise directs the operation of such order shall not be suspended by virtue of an appeal under this section, and every such order may be enforced in the same manner as in all respects as if no appeal under this section were pending. Protection of mortgagee. Section 20. Protection of mortgagee. Subsection right. 1. The rights conferred on any person in respect of any property by an order made under this act shall be subject to the right of any person entitled to the benefit of any mortgage, security, charge, or encumbrance affecting the property, if such mortgage, security, charge, or encumbrance were registered before the making of the order, or if the rights of the person entitled to the benefit arise under an instruction or under an instrument executed before the date of making the order. They seem to be saying that if the person who normally pays the mortgage or rent is thrown out of the house by the court, that person must still pay that mortgage or rent, even though they are not living in there for such period that the court takes them away from the property. That seems to be what this is saying. Subsection 2. Notwithstanding anything in any enactment or in any instrument, no money payable under any such mortgage, security, charge, or encumbrance shall be called up or become due by reason of the making of an order under this act. Section 21, Matrimonial Causes Act. This act shall not affect the power of the Supreme Court to make orders under Section 10 of the Matrimonial Causes Act. Section 22, Rules of Court. Rules of court may be made by the Rules Committee constituted under the Judiciary Resident Magistrates Act for the purpose of regulating the practice and procedures of the court in proceedings under this act, providing for such matters as are necessary for giving full effect to the provisions of this act and for due administration thereof. So that's the end of the Domestic Violence Act.